Hi, my name is Sergio Ardila, and I have been the top workers' comp attorney at our Atlanta office for the last 7 years. This video will give you a good understanding of what you need to know and how to prepare for your workers' compensation deposition. Please only use this as a guide for general information and make sure to ask your attorney specific questions about your case. A good attorney will talk to you before your deposition and make sure everything's understood. You may be wondering what a deposition is, or what you need to say, or who will be there, and specifically, how do you prepare? Let's start from the beginning. You have a workers' compensation claim, and you or your attorney saw that you were not getting all the benefits that you deserved. So, you requested a hearing and started litigation. Litigation gives the defendant some rights, and one of those rights is that they get to depose you and get information about you and the facts behind your claim, and the benefits that you're arguing that you're entitled to. So, the insurance company is sending an attorney to ask you questions. By the time this video is over, I am confident you will have the answers to the questions you might have about your deposition and understand the deposition process. Of course, if you still have questions or any concerns after watching this video, please contact your attorney's office and get answers to those questions. Here at my firm, we are here to make you feel as prepared and comfortable as possible. So, here are the logistics of a deposition. There are usually 4 people at the deposition: the court reporter, you, your attorney, and the attorney that will be deposing you. The court reporter will be there to type out every single word that is said. The deposition is one of the only opportunities the defense gets to ask you questions directly, and your duty is simply to answer those questions truthfully. The truth is the most important thing to remember about your duty, and we will talk about that later in the video as well. We'll prepare you beforehand, and you won't be there alone. But it's an important moment because the impression that you make during the deposition can have a big impact on whether they want to go to trial with you or whether they want to settle. You will first be put under oath by the court reporter, and the defense attorney will begin asking you questions that you're required to answer. The key is answering honestly, straight and short. It's important that you are perfectly clear that a deposition is not your day in court. There's no judge and there's no jury. Most folks want to tell their story, and a deposition can kind of feel like court, but don't confuse one for the other. If your case doesn't resolve fairly, you will get your day in court where there will be a judge and there will be an opportunity to tell your story. But the deposition is not that time. This is an opportunity for the other side to try and get information, and if they can, in the process, trip you up. You need to be mindful of this. They're not there to help you. Don't let them sweet talk you into getting your guard down and forgetting these things we're going to talk about. At the same time, however, you don't want to treat them like the enemy. You want to be pleasant to them. Not sappy nice, as that would not be sincere, but simply pleasant. When you get into the deposition, you can say yes or no, or yes sir, or yes ma'am if you want. If you don't understand a question, you can say, I'm sorry, do you mind repeating? Instead of something more confrontational like, I don't know what you're asking me. It's okay. You can ask them to repeat a question if you don't understand. It's how you do it that I'm highlighting here. Remember not to volunteer any additional information. For example, they may ask, when you fell, how did it feel? Or what did it sound like? You might answer, it was loud and it jolted. I felt pain right away. And you may want to say, then I called 911. Don't. Try to think about what is it that they're asking you. If they say, how did it feel or how did it sound? Simply answer the question that is asked. In the example, you could say, it felt very painful or it was loud. But you don't have to say you then call 911. That is not the question that was asked. They will probably then ask what happened next, and then you can answer that you call 911. But if they don't, it doesn't mean that it's left out of the story. It just means that they don't know that part of the story, and the less likely they know, the less prepared they will be at trial, and less likely they're going to be able to hurt your case. As a nice, easy to remember rule, if you are answering any question in more than 2 sentences, you are answering too much. Make them keep asking what happened. Next two sentences, that is. So, remember, answer the question honestly and in the fewest words possible, and do not volunteer information. Watch these types of questions carefully. For example, tell me everything, list everything, and is that all? These are questions where the defense will try to get you to limit your answers so that if you later try to claim anything in addition, they can say, you remember when I took your deposition and I asked you to tell me every way that your back hurts. And I asked specifically, is that all? And you didn't tell me any others and you were under oath. Now, you might become a liar in front of the judge and that could be fatal to your case. So, how do you handle that situation? These questions should never ever be answered with a yes or no. They should always be answered with, that's all I can think of right now, or that's all I can recall. Leave yourself an opening, otherwise you may be forever limited to only those answers that you provide at your deposition, which is unfair because often we forget things. It's part of being human. Often more details come to us after the deposition, they just do. It's extremely important to leave yourself an out. Leave yourself that ability. Also, remember that it is human nature and a big part of human nature to try to convince others of the righteousness of our case. It's only natural that you will try to convince the defense lawyer of your case. Do not waste energy doing this. The defense lawyer is being paid hundreds of dollars an hour not to believe a word that comes out of your mouth, and likely they're trying to make you out to be a liar. We are simply there because it is a duty to answer their questions. That's it. The defense is going to be asking you a lot of questions during your deposition. It's probably going to take a couple of hours. The other lawyer will likely begin by asking you general questions about your background, your education, family life, work history, and the facts leading up to and surrounding the work injury. Some of the questions will be personal in nature, and some uncomfortable, but the law gives a broad standard directing what type of questions they can ask. Be aware that a significant portion of the deposition will likely focus on your past medical history and your current symptoms. Of course, every deposition is different, but this is typically how a workers' compensation deposition goes. Listen to the question carefully and fully, and if you understand it, go ahead and answer it truthfully and in as few words as you can. While they're asking you these questions, you might be thinking, what does this have to do with my case? What does this have to do with the work incident that I was injured in? Well, this is what is called a discovery deposition under the law. What that means is the defense is allowed to ask you a broad range of questions. The only questions they're not allowed to ask are questions that we call privilege. For example, they're not allowed to ask about conversations that you had with your lawyer. If they ask you one of these questions, your lawyer will instruct you not to respond. But a very high majority of the questions they ask, if not 100% of them, will not be privileged questions, and they will be questions that you will need to answer truthfully. Remember, not to get defensive or upset, and not to ask questions like, why are you asking me that, or why is this relevant? I can't speak for every attorney, but when dealing with most good attorneys, unless your lawyer instructs you not to answer, it is likely a question that they are allowed to ask. Remember that a deposition is not an endurance test or an interrogation you see in the movies. If you need to take a break, go to the bathroom to gather your thoughts, speak to your lawyer, that's absolutely okay to do. Just remember that before asking for a break, you want to be sure that you've answered whatever last question that was asked. On the day of your deposition, make sure that you don't bring anything with you unless your lawyer instructed you to do so. This is because there are different rules when it comes to discovery of documents, and we want to make sure that they follow those rules when obtaining those documents. So, no list, no diaries, no journals, no cell phone with pictures. Leave that in the car. If you don't remember the answer to the question, don't look it up during the deposition. The defense lawyer is going to be asking you a lot of questions about a long period of time spanning back years and years in your life. If they ask you a question that you don't know or you don't remember, it's okay to say, I don't know or I don't remember. But you want to be honest and credible on those answers. So if you do remember part of an answer, but not the whole thing. You can let them know you are not sure and answer the part that you do know. For example, if they ask you the name of your high school or the name of your college and you say, I don't know, that doesn't sound very credible. Maybe you've forgotten the full name, maybe they've changed the name since you graduated, but a partial answer of what you do remember is more credible and more honest than simply, I don't know. Now, if they ask you a question that you simply cannot remember at all, or you just absolutely do not know, like the speed of the other vehicle in a car wreck, then when you answer I don't know or I don't remember, they're not allowed to continue to pry. They will have to move on. It is very important to never deny the truth. If you have previous injuries, admit them. If there are issues that are true, acknowledge them. Remember, don't volunteer any information, but acknowledge if asked. The defense spends an incredible amount of money investigating you, your social media, your medical history, your employment, everything. It would be a horrible and potentially fatal mistake for you to fail to disclose any information thinking, oh well, they will never find out. They will, and they can ruin your case because you have just committed perjury in that case. Every case has good and bad facts, and we can help you with almost any issue other than perjury. Remember that a majority of the questions being asked during a deposition, the defense already knows the answers. Again, it is a test to see if you're credible and believable and tell the truth. The defense will most likely have already pulled all past insurance claims you were involved in and will likely have already subpoenaed your medical records. As a practical tip, I suggest you watch this video a few times and at least the night before your deposition. Remember, we are here to support you throughout this process, and please let us know how we can help you be better prepared and feel more comfortable for your deposition.